with each one of us, the presenters and all of us, even as the day proceeds. We honor you and bless you, and we surrender this day into your hands. Take full control. In Jesus' name we pray. Amen.
Thank you so much. We'll go straight into our program. We have a very interesting topic: the role of prosecutors in upholding democratic tenets in elections. To help us canvass this topic, we have Mr. Alois Kemo from the Office of the Director of Public Prosecutions for Kenya. Ladies and gentlemen, help me to welcome Mr. Alois Kemo.
The DPP Zambia, I think my fellow facilitators, colleague prosecutors, good morning. Seems like you didn't have breakfast today. Good morning. Back home, I am a teacher. They call me the headmaster. It was just before I became Secretary Prosecution Services, I was head of the Prosecution Training Institute. And we look forward. Are you ready with the presentation? Yeah, so just as we spoke yesterday, arising out of that violence in 2007, it became very necessary for us as law enforcement agencies to also up our game. And subsequent to the elections in 2007, we have all been forced to innovate, to think out of the box so that we are not caught unawares, because you don't want to be in the situation in which we were in 2007. When violence breaks out in a country and it quickly spirals throughout the nation, I think some of us saw a nation that was crumbling. Nothing really could happen. I remember I was working in Nyanza region in a place called Kisii. And Kisii was just about 20 kilometers from home where my mother is. But for 2 weeks, I could not get home. A distance that usually took me at most 20 minutes by driving, because all the roads were blocked. And even the day I managed to penetrate, as I was approaching home, just about 2 kilometers from home, I remember young men who had blockaded the road approach me and say, "You are enjoying driving and we are fighting for the nation." With a very big stone, they wanted to throw it on my windscreen. And I said, "I'll pass with this one." Fortunately, he ran away. So we really have to be vigilant, even as the election progresses. And I just will share with you what we as Kenya have done, and hopefully you can learn something from the experience that we've had. So please take me to the first slide. Now, the highlights of this presentation, we are going to look at, this is yesterday's. Is there some confusion? Innocent? Oh, the questions. Oh, okay. Yeah, thank you. So I'm told we'll take questions from yesterday's.
Ladies and gentlemen, Mr. Nkemo yesterday gave an insightful presentation on the committees, and we had promised that we would take a set of questions for him. would spare at least 3 minutes for the questions. Any interventions? Any interventions on yesterday's presentation? I see none. We'll allow Mr. Nkemo to proceed with his presentation for today. Thank you.
I take it that you have adopted it as a resolution. You're going to have the CUCs in the manner in which we are applying it in Kenya. So for today, we are going to discuss the role we as prosecutors have in upholding democratic tenets in elections. And as I said yesterday, as a prosecutor, I think our principal role is just to hold those who perpetrate election offenses to account in a fair and impartial manner, without regard to what positions they hold or what positions of influence they may have in the community. That is our basic responsibilities as prosecutors. But elections, you know, in Africa are typically very volatile. And as you could see from the clip that I played yesterday, are characterized by chaos, protest, unrest, violence. You saw running battles with the police. There's a lot of oppression, loss of lives. Oppression, as you could see from, was it called Mr. Mashauka yesterday, the witness who talked to us. Destruction of property, human rights abuses, and media blackouts. Media blackouts in the sense that sometimes we experience a blackout even in terms of reportage of what is happening. And generally crime goes up during that time. The electioneering period is a time when safety and stability of a nation are most vulnerable, just as I've demonstrated to you as we began speaking. As witnessed in the past, the aftermath of elections are a wake of destruction, loss, and emotionally charged community. Such a situation is a breeding ground for crime and violence, which happens indiscriminately, and it affects women, children, who do not take part in the elections. I think we'll skip the film. We saw the film yesterday. Just take me to the next. Next. Take me to the overview and my highlights of this presentation. So we'll just introduce I think I've done the introduction. We'll look at the principles of democracy and the ones that are relevant to us, the legislative framework regionally and internationally, the link between the prosecutor and democratic elections, why that link is necessary, stakeholders in the whole government approach, and I believe from the presentations that have been made, you have also adopted this whole government approach to the way you enforce the law in your country. Offenses that are manifest in a space without democratic tenets, the role of the prosecutor in upholding democracy in elections, practical tips on elections preparedness, the Kenyan experience, some of the challenges in prosecution of electoral offenses, and maybe a suggestion of the things that you'd want to consider as we move forward. Next, please. Now, regarding the principles of democracy, And there are very many. I just chose the few that I thought were relevant and which we should have at the back of our mind as prosecutors, even as we go into this electioneering period. Now, these tenets are the core principles or doctrines that must be present for an election to be considered fair and democratic. They are anchored in Article 21 of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the African Charter on Elections, Democracy and Governance. These tenets are mostly enshrined in the Constitution and electoral laws of any country. Now, in Kenya, with the Constitution that we gave to ourselves in 2010, under Article 3, any treaty or convention that has been ratified by Kenya forms part of our law, and we can apply it just the way we apply any of the statutes. And I think that was done so that we could hold people to account for offenses that had been committed, offenses that, were described. That, I think, is what led to our fourth president being arraigned before the International Criminal Court, the fourth president and the fifth president, who was his deputy that time. You don't want that kind of thing to happen to you as a country, because I think it was the most shameful thing to see our president, sitting president, hold and take a plea before the International Criminal Court. But it was because of the things that had happened in the country that, we needed to have somebody account for those offenses. So these tenets include universal suffrage, that every citizen has a right to vote, and voting rights must be exercised without discrimination. I believe you are all voters, or most of you are voters, and you appreciate that principle. Then there is the principle of equal suffrage, one voter, one vote. Each vote must carry equal weight. Whether you are an 80 or a 90-year-old, the weight of each vote is the same. Then there is the periodic and regular elections. I believe in Zambia it is every 5 years, just like in Kenya, that elections must be held at predictable intervals and between different candidates to allow for free choice of people. Next, please. There is a principle of political participation, that every person has a right to participate in an election without discrimination. Secret ballot, that a voter's choice should be private and free from coercion, intimidation, or retaliatory attacks. Most importantly, for prosecutors, the rule of law and dispute resolution. And here we are talking about having a legal system that protects electoral rights and provides clear, fair avenues for redress in electoral complaints. Then a free and fair elections, that the entire electoral process must be free, fair for all candidates from the beginning, during the campaigns, during the elections and after the elections, including the legal redress mechanisms. And here you must note that during an election, democratic tenets do not apply only on the day of the actual election, but during the campaign period, through up to the end of the elections. And for us, we normally have a problem when the announcement is made. Next, please. Now, the legal framework, international and regional. So we have the International Declaration on Human Rights, Article 21, which outlines that a person's rights to take part in the government and public affairs of the country. The International Covenant on Civil and Political Rights gives life to Article 21, also noting that those rights cannot be exercised without freedom of expression. assembly, association in relation to political issues of a country. And we see sometimes when in political contests, people change camps. The Constitution guarantees that everybody can associate with whomsoever they like. But sometimes people are targeted. They could be abducted, they could be harmed. And that is where we come in as prosecutors. The African Charter on Human Rights and Human and People's Rights, Article 13 outlines the right to political participation and outlines other enabling rights to democracy. Article 9 of freedom of expression, Article 10, freedom of association, and Article 11 on freedom of assembly. Then the African Charter on the Elections, Democracy, and Governance aims to institutionalize a political culture based on electoral integrity, anti-corruption, rule of law, and democracy among member states. Next, please. As I said, Article 2(6) of the Constitution of Kenya has domesticated ratified international treaties and conventions to form part of the laws of Kenya, binding the state to observe and implement provisions, their provisions including each of those instruments that I've just highlighted. Now, the violation of these international instruments makes Kenya accountable to international tribunals and courts. And as I've said, in 2007, we had our president and the deputy president that time, and four others presented to the International Criminal Court just to answer to charges for offenses that occurred during the 2007-2008 elections. These cases were, of course, dismissed for insufficient evidence, but the impact on the victims can be felt to date. Yesterday, in the clip you saw that some people were internally displaced. We are talking about almost 20 years now, and some of those people have not returned to their homes. So the impact of these offenses during electioneering period can be quite traumatizing to victims of crime. Next, please. The prosecutor and democracy. So what is the link between the prosecutor and democratic elections? A prosecutor is the gatekeeper within the criminal justice system. Law enforcement and courts can exist, but they need a prosecutor to complete the chain in access to justice. We literally stand at the door. Anybody who wants to access that justice in criminal cases must come through the prosecutor. So the prosecutor's role is to ensure that the law is applied fairly, impartially, and in accordance with the rule of law and democratic tenets by addressing crimes resulting from election-related activities. And as a gatekeeper to democratic society, a prosecutor must hold to account any person who breaches the electoral law. The chief role of the prosecutor is to represent the public interest by pursuing justice rather than simply seeking convictions. And I believe as prosecutors, you know this code. So a prosecutor's role in democratic elections touches on the following critical functions. With regard to investigations, to ensure that they are impartial and conducted according to the law. And in my experience, because I've seen so many elections in my life as a prosecutor, it is during elections that you will find very old cases being revived. Cases sometimes that happened even when somebody was in school. And they are all introduced just to tarnish the name of individuals, just to see if they could be prevented from, vying for certain positions. So we must ensure impartiality and that all those investigations are conducted in accordance with the law. Sometimes files are presented to you without any tangible evidence at all, but there is pressure that you prefer charges, any charges against those individuals. Now, the other functions is to safeguard the rights of both the suspect and victim from human rights violations. I believe that is very, very clear. Ensure due process is followed by other actors in the justice system. And as prosecutors, as I said earlier, you are the gatekeeper within the criminal justice system. So if police are violating the rights of individuals or any other investigative agency or other agency that has a role in the elections is not following due process, then you as a prosecutor must see to it that every institution is acting within the confines of their mandate. Then in terms of interagency collaboration, to advise on matters touching on application of the criminal law, because I believe this position obtains even in Zambia, that you are the advisor to the government on all matters criminal law. Next, please. So why is that link necessary? That as a prosecutor, as a key player in the whole of government approach, protects national values by addressing violations resulting from election malpractice. And this is done through execution of each of the prosecutorial mandates. Separation of investigative and prosecutorial power is in itself an accountability mechanism against police excesses and abuse of power. And I'm happy to note that Zambia also has gone this route. We in Kenya have professionalized prosecution. There is no prosecutor who is not a member of the bar. They are all qualified advocates, technical people in the law who should know the values that guide us as advocates. Without the prosecutorial agency taking action as per their mandate, the result shall be eroded trust in the democratic processes, gross human rights violations, and a degradation of social and economic rights. It is in the broader public interest that a prosecutor acts legally, firmly, and decisively in matters of electoral justice as development goals anchor on the stability of the nation. You may want to ask yourself occasionally, what contribution do you make to the development of the nation? And the answer is very simple. By holding people who violate the law to account, you create a conducive environment for those who may want to invest in the country. Nobody wants to come and invest in a country where there is chaos. Nobody wants to invest in a country where if a crime is committed against them or their investments, nobody will be held to account. And that is the reason why we as prosecutors are very important. You must understand that connection in having a stable nation. Now, the mandate of prosecutors to direct investigations into particular matters with specificity guarantees the operation of the rule of law. Don't be that prosecutor who, when you see something happening in the community in which you serve, you just keep quiet. I believe you have the power to direct investigations to be carried out, the file submitted to you for your review, and for the purposes of taking action if there is sufficient evidence. So we must be very alert to the things that happen around us. And in Kenya, during elections, as I will demonstrate later, we monitor even the social media posts, so that if we see some hateful utterances, if we see some threats to violence, we preempt by asking the police or the relevant investigative agency to undertake investigations and submit the resultant file to our officers for directions. Now, prosecutions send resounding messages to agencies which intend to undermine the rule of law. So when you do that, inevitably, you send very strong messages to your partner agencies that they must enforce their mandates. Now, what is the whole of government approach? And do you have this DPP, whole of government approach? Somehow, I know maybe you do it, but you don't call it whole of government. But where all agencies, for example, in the enforcement of law, come together, you have multi-agency task teams. The whole government embraces a certain issue, like on these matters electoral. The whole of the government approach means that all agencies in government, all departments in government come together to ensure that they have a common objective in ensuring that the electoral process goes on smoothly. From the onset of a matter, and in this context of whole government approach, prosecution-guided investigation should be employed as an international best practice. I think yesterday we talked about, and other speakers also talked about, you sitting with investigators as the technical people in the law, guiding them on what evidence they need to gather, guiding them on, technical issues such as admissibility, and all these other things that an investigator needs to know so that you develop strong cases with, chances of success. Now, involving agencies in the criminal justice system in good time not only saves time, but also produces better quality results. And who are the key parties you must involve? Like in Kenya, we have investigative agencies. I talked about the National Police Service, the Ethics and Anti-Corruption Commission. We have the National Integration and Cohesion Commission, which investigates hate speech and other related matters. We have Independent Police Oversight Authority, which oversees the police and investigates offenses that may be committed by the police, particularly around election time. We have the Witness Protection Agency, and even though this presentation of mine does not cover Witness Protection Agency, let me just mention in passing what it is in Kenya. In Kenya, it is a very big deal, particularly during elections. You know, there's a lot of intimidation, and we are dealing with people who have influence, politicians or very senior government officials who have a very high stakes in the outcome of elections. And so, in Kenya, we have the Witness Protection Act, which establishes the Witness Protection Agency. And basically, it just provides for a framework of safeguarding those who are likely to testify in criminal cases or in tribunals or commissions that may be established to inquire into any matter that is sensitive for the purposes of the nation. And that framework is meant to, protect vulnerable witnesses. And the way in which this can be done is through identity concealment in cases that have previously handled. A case that was very controversial against an evangelist who had caused death by dangerous driving. He's a very controversial evangelist in Kenya. It became very difficult even for the police, because I think from the very beginning he tried to influence the investigations. So it was after an outcry from people who were on that highway, the national highway from Nakuru, Naivasha to Nairobi, who witnessed the accident, that said the accident did not occur in the manner in which it had been reported. They saw clearly who had come out of the driver's seat in the Range Rover that caused the accident. And And that, therefore, got the DPP thinking, and we directed that the in charge of traffic in the country takes over personally those investigations, undertake investigations and submit the file to us. And one of the first things we did was to identify those who are going to testify, and we liaised with the Witness Protection Agency just to make sure that they were protected and that they would not be harmed. So identity concealment is very important. When we went to court, some of those witnesses, we dressed them in kanzus. They were wearing goggles. A kanzu is this Muslim attire, you know it. They would wear the Muslim cape and goggles so that nobody could identify them. Sometimes we have witnesses relocated. They could be relocated within or outside the country so that influential people do not get to them. There are also measures such as a change of identity. You may change the identity of an individual so that if they are not known but they come to court, they have different identities. Other measures the Witness Protection Agency can apply, particularly in court, they can request for in-camera proceedings, use of pseudonyms, relocation of, I've said, the identification of the informant, and sometimes use of video link. In Kenya, as it is right now, sometimes we also use virtual proceedings to conduct cases. So this is not a challenge as it was when this act was enacted. And then, of course, measures to just obscure or distort the voice of someone who is testifying. We could also have witness boxes in court where a witness just sits. The witness box, it is concealed. You can have a one-way glass, the vision, I don't know how you call it, but you know what I mean. The glass where if you are sitting inside, you can see what is happening outside, but whoever is outside does not see who is inside testifying. So those are some of the measures that we use in that regard. Next, please. Prosecution-specific task teams. The ODPP, the Office of the DPP, is part of a multi-agency task team on electoral justice that comprises prosecutors and investigative agencies only. And during the election period, this task team meets regularly to strategize on investigation and prosecution of cases and brief their respective principals on any issues they may need redressed. So like my team, which is the ODPP Election Preparedness Team, sits with other teams from the investigative agencies. We normally have the Ethics and Anti-Corruption, the Director of Criminal Investigations, Independent Police Oversight Authority. There is also an internal one within the police, which holds them to account for misconduct. We sit together and we discuss any issues that may arise. And our task basically is to develop strategies. Where we need the input of our principals, in my case the DPP, we brief them. Sometimes the principals also come together in a meeting room, and we would also sit in and brainstorm on how best to address certain issues. And all those are the agencies that we work together with. We have the Kenya National Commission on Human Rights, the National Cohesion and Integration Commission, which is very important, particularly when you are discussing hate speech. Those are the offenses that may manifest in a space without democratic tenets. I think someone took us through this yesterday. We don't have to go through all of them. Personation, voter bribery, participation in elections by public officers, unlawful expenditure. All this were discussed yesterday, and we are a common law. I think these are common between our countries. International best practices. Knowing the impact of the lack of prosecutorial power to the country, a prosecutor should intimately understand their duties and responsibilities in prevention of and in reaction to electoral offenses. These duties involved, as we have talked about, and this is very important, where you are handling a complex case, I plead with you, particularly the young prosecutors, and I'm told there are rookie prosecutors in the room, please adopt this culture as early as today. Guide investigative agencies on the line of investigations to pursue, the evidence to be collected, preservation of evidence, and potential charges to be preferred. This brings about precision in investigations and in prosecutions. If time allows, we'll look at some of the benefits of prosecution-guided investigations. You call it decision to prosecute. In Kenya, we call it making the decision to charge. And we have a whole set of guidelines on making the decision to charge, what a prosecutor needs to take into consideration. Now, as we call it in Kenya, the DTC should be independently and impartially done. Resist and reject undue influence. You are dealing with politicians. You are dealing with people who have a lot of influence in the community or in the nation. And therefore, it is real. I have seen it myself. There are times when I, as head of the election preparedness team, made a decision. And the next person placing a call was the Inspector General of Police and saying, you must assist us in this case. And my mode of operation is that before I make a decision in a case, always I talk to the DPP and tell him, DPP, this is the file that we've received, and this is my opinion about this matter. And it is important that you have the DPP's backing on any issue, particularly when you're dealing with those difficult or influential characters. He will have your back, otherwise you'll be roasted. So make sure where, and the barometer, it is you who knows which matter you need to consult the DPP about. So they would call and I would tell them, hey, look here, you sit with the DPP in your forums, please talk to him about that. If he gives the directions, I'll follow. But personally, I've made the decision and I'm done with it. I think any other decision can only be made by the DPP. So you must have a way in which you can talk to those people. That would be difficult for you to bind the DPP if you had not talked to him about that case in advance. This is your power as a prosecutor. Relinquishing this power is a betrayal to the people of your country. Remember, it could cost the country the leader they want if you lower your guard. So make sure you are not influenced unduly during that time. Now, considering alternatives to prosecution in deserving cases is the way of the thinking of the 21st century prosecutor. And I believe you've looked at those principles prescribed by the United Nations. For those young prosecutors, the 21st century prosecution guiding principles. And in it, you'll find alternatives to prosecution. It is no longer in fashion, just behaving like the traditional prosecutor, charging in every case. You must look at the circumstances under which an offense was committed and decide at the very early stage, once you make the decision to prosecute, whether it would be in the public interest to proceed. So in deserving cases, consider plea bargaining and diversion or any other alternatives and ensure they are in the interest of justice and that it is the most appropriate course of action towards democratic practice. In this context, under the National Cohesion and Integration Commission Act, we have a provision that provides for promotion of reconciliation. Where there has been hate speech, Some people sometimes make utterances against certain communities because they perceive those communities as their rivals. That is very common in my country, in Kenya. And where that happens, the elders in one community may meet the elders in another community and agree to resolve that issue. They could draw down to an agreement and give undertakings that that is not going to happen, apologize, perhaps even have a meal and a pact, and that pacifies the nation in some way. So those are issues that you may want to consider, because when you prosecute an influential community leader, it may not end up with the desired result. So when you consider diverting that matter and having a reconciliation, it's a more effective way of resolving some of those issues. Witness protection considerations, I have told you about that. I know you don't have this framework as yet, but at a very early stage, when you are reviewing the file, for example, me in my case, any file that comes to me for prosecution, one of the first things I do, I look at the kind of testimony someone is giving. And the testimony is against who? If it is against a very influential person in the community or in the nation, I may want to consider at that very early stage contacting the Witness Protection Director and request that they consider placing that witness under protection. Even though you do not have that framework, I don't think anything precludes you from arranging for the relocation of a witness. Those arrangements can be made. In any case, it's an international best practice. It is happening in the Commonwealth, and nobody would take it against you if you organized for that. So the sooner you embrace this practice, I think the better for you going forward. In terms of pretrial issues, we must address issues of chain of custody. I think someone alluded to this yesterday. Special considerations during trials like adducing digital evidence. Again, this was done yesterday. Use of special aids, special vulnerable witnesses in good time. I've just told you about the witness box that we use, or a video link testimony. All those are things that you resolve during the pretrial. You make sure that at the pretrial session, you inform the court that this is what you will expect, or this is the infrastructure you will require when the trial begins, so that all the logistical arrangements that need to be put in place in good time are done of the hearing. In terms of sentencing, from the very beginning, the prosecutor should document the adverse impact of the crime to the victims in preparation for submitting a victim impact statement to the court during sentencing. This tradition has not caught, but it is very, very important. And it, humanizes the work that we do. When you hear how the case you are prosecuting has impacted the victims, it allows you to empathize with them and kind of go out of your way to seek justice for those people. And this also aids the court in sentencing and awarding appropriate remedies. The court may have just contemplated meting out a sentence without, considering that a compensation order would be necessary. After hearing the victim impact statement, a court could go out of its way to ensure that appropriate remedies are also considered. Now, in terms of collaboration with stakeholders, maintain the justice chain from the beginning to the end of a matter, take the burden of the following up through different agencies of victims and witnesses. I think I cannot overstate the importance of collaboration. Then monitor and analyze trends and their root causes. A trends analysis in crime identifies hotspot areas for specific crimes, informing appropriate interventions per region, as opposed to one-size-fits-all model. It informs on sensitization topics, appropriate sentences, and policy formulation. And in the last election, I remember we had some interns who, working together with our ICT people, developed for us a platform called Ushahidi. And Ushahidi was an app through which our focal points in all our offices would enter the details of the cases they had registered or cases that they had noticed in their respective areas. And from the central command, because I'll talk about it in a short while, we were able to monitor the prevalent offenses region by region. So you need to monitor and analyze the trend analysis because it will inform what interventions you'll put in place in those areas. It may inform the topics you may want to sensitize on and other issues. Then sensitization of stakeholders is very key. As prosecutors, we normally sensitize investigators, particularly on the decision to charge guidelines, so that they are aware what we take into account when making the decision to charge. What the impact of the crime is to the individual and their role in the economy and democracy at large. Then we engage also with the media to encourage ethical and responsible and accurate reporting, because this can also heighten tension amongst the citizenry. And so use of media platforms to sensitize on benefits of democracy. And I personally, as the chair of the ODPP electoral preparedness team, have severally appeared either on national TV, discussing together with panels, and on various forums, basically just to discuss matters elections. So what is the role of a prosecutor in prosecution-guided investigations? You assist the investigator during investigations, you evaluate the evidence together. Most importantly, from a very early stage, you develop a legal theory and a charging strategy with the investigator. You assist in determining the next investigative steps, timing of searches and arrests. Maybe you are the only prosecutor in your station. You are attending this forum, and the police are arresting someone today and taking him to court tomorrow. You will not be in the office. That's the reason why it is important to coordinate the timing of searches and arrests. In Kenya, it is important for us because when you arrest somebody, within 24 hours, he must be produced in court, unless it is the weekend or there is a very special reason that you can use to justify the holding of a person beyond 24 hours. The other thing is you evaluate witnesses and take steps for the vulnerable witnesses, including contacting the Witness Protection Agency. You also prepare warrants and court documents, warrants for searches, and any such interlocutory applications that you may want to make just to facilitate investigations. You prepare the charging documents, you respond to advocates. In other words, when you involve yourself from a very early stage in investigations, you then appreciate all the weak points and the strong points about the case. And when you go to court, you cannot be taken by surprise because you'll be able to respond effectively to any challenges that may be raised by the advocates. And then you are able to prepare the witnesses and exhibits for trial because you know everything about that case. And ultimately, you are ready to conduct that trial in court. Next, please. So those are the benefits of prosecution-guided investigations. From the perspective of the prosecutor, you gain early familiarity with the facts, as I've just said. Because you are involved, you are analyzing the documentary evidence. You are assured of accurate court documents, and you can lay a basis for producing such documents. There is efficient identification of key testimony and evidence. You can tap into the investigator's knowledge. You saw the experts we had here. You can tap into their knowledge. You are able to better coordinate witnesses. And my style, and what I normally tell prosecutors, you should prosecute in a way like you are telling a story, so that it unfolds. It creates the interest even in the judicial officer who is hearing the case. And when you have the attention of the judicial officer, they keep yearning for what is coming next. And it's a very good strategy, because that is how you get the court to start believing in your case. So you are better able to coordinate the witnesses. You are able to respond to surprises at trial, because you understand this case right from the beginning. You are involved even through the investigation process. You are able to prepare the investigator for testifying. You can guide them on the areas they need to focus on, lay emphasis on, to be able to present a strong case. And then, of course, it gives you an opportunity to resolve disagreements between you as a prosecutor and the investigator. For the stakeholders, the court, the public, and all other stakeholders, they see more efficient and effective investigations, because you develop very watertight cases. They see successful trials, and nobody, least of all the prosecution authority, wants the public to have confidence in the work that it does. So when they see successful trials, it boosts the public confidence in the work that we do. Then they see strong ongoing relationships, which is very important for people when they want to know they are in an environment in which the rule of law prevails. There is less miscommunication. Every time maybe the police want to go say something out there, they consult with you, or they act in conformity with the MOUs or the practices that you have. Then there is greater judicial confidence in the prosecution, because they see you are serious with your work. You are presenting very strong cases. I've already talked about greater public confidence. Next. And this is the Kenyan experience. I think this is the reason why I traveled to Zambia. Now, the ODPP has adopted and implemented mechanisms that have proved very beneficial and practical in handling electoral-related matters. Number one, we have a dedicated division to hate speech and electoral justice. It is headed by a Deputy Director of Public Prosecution, and with a group of prosecutors in that division. Then we have focal point prosecutors in all our counties. They are trained extensively on electoral laws, malpractice, offenses, decision to charge in election cases, and special considerations they may need to have on matters to do with hate speech. The mandate of that division is to receive and review all files relating to electoral and hate speech offenses. Of course, when they review, sometimes they have to escalate to the DPP for directions. But those files, their first point of call in our office is at this division. They make the decision to charge in election-related matters. They advise police and all other investigative agencies on their cases. They are the prosecutors who attend court to prosecute. And I insist that the focal point that we choose in the county is the person who should prosecute those cases, unless for one reason or the other they are not able. This is because we have trained them. They have an obligation to report to us as a national team on how they are conducting. Every time they come from court, they must file returns to the head office through tools that we have created. Then there's the case intake and data analysis that they do. I've told you about the trend analysis that we have to do. Then the division is based, as I said, in the headquarters with the liaison or focal point persons or prosecutors all over the country. Number two, we have developed a compendium on hate speech and electoral justice. This compendium contains all information relevant to the prosecutor to empower them to prosecute hate speech and election-related cases. This compendium contains the legal framework. In other words, all the legislation on hate speech and electoral justice. It contains the role of the prosecutor in hate speech and electoral justice cases. It is important for them to know because we could have onboarded a prosecutor who has no knowledge about how we handled. So when they refer to the compendium, they can better be able to understand their role. It contains all the offenses related to hate speech and electoral justice, the sections and the enabling legislation, the ingredients of each offense. We have the witness protection measures that can be put in place. It guides them also on how to draft charges, because these are not your day-to-day offenses. So we have sample charge sheets because we want also that when they make the decision, they are able to make clear charges that may not raise issues in court. The requirement of a police investigation file in hate speech and electoral justice matters, and who the stakeholders are. And sometimes I encourage my prosecutors in their respective regions in which they work to map out who the stakeholders or agencies they can partner with, particularly during this electoral period. Now, when the election period is declared, as I've said, the task team is appointed, and it includes members from the hate speech and election-related division to coordinate logistics related to electoral justice. It includes mapping out the stakeholders. That is what we do as a first step. We also prosecute those matters in court. Depending on how serious they are, we determine the level of prosecutor who's going to attend court. We organize trainings and we do regional trainings. We take these trainings to the regions where the prosecutors are. And sometimes when we go out to the regions, we also do community sensitization. We do community dialogues around those issues. And one thing we have also encouraged, if we go to a region, we will look for a prosecutor who speaks the dialect in that region, so that usually very early in the morning, before we do the community sensitization, they'll appear in the FM station of that particular area and sensitize the public in vernacular language on the message that we want to pass. Now, this team is also responsible for the technical aspects as the technical people in the law. Now, the other thing we do is that we have a 24-hour call center. This center is a toll-free call center where members of public can call to report offenses, seek advice, or give information on electoral malpractices. This call center is run by prosecutors who can advise appropriately and coordinate with investigative agencies to investigate swiftly. This is something we do 2 weeks to the election because it's normally very, very involving, because you have to create a duty rota covering the 2 weeks. So there will be prosecutors manning it during the day, and there will be prosecutors that will be manning it in the evening. You have to think about the food they are going to eat there. They have to have that toll-free number, which has to be manned throughout, and so that you are able to respond. Computers with enough data so that they are able to communicate, they are able to follow up on social media. Prosecution-guided investigations. Again, this is done during the campaign period, during elections, after the elections, and announcement of the winners, to ensure investigations are done promptly and evidence is gathered for a watertight case. This is further necessitated by the 12-month timeline given to prosecute election-related matters. Then, in that call center, we also have prosecutors who monitor social media sites. In addition to this, the team also does monitoring of the media. What is on the print media, what is on the mainstream mass media, social media sites like Facebook, Instagram, X, and material that is shared on social media platforms such as Telegram, WhatsApp, amongst others. This is important because sometimes when people are attending rallies, there are people who are capturing images of what is happening. In Kenya, the police were provided with the gadgets that they could use to record incidents, say, for example, during hate speech. They are meant to attend public rallies or campaign rallies undercover and to make sure they record those events. But the sad thing is that we have never received any recordings from the investigators using those gadgets. And so we are left to follow some of those things in the social media so that you can try and trace whoever recorded them and follow the digital evidence guidelines to see if it is something that you can use. But it is also helpful to help us map out the areas, the hotspot areas, and where we need to focus. Next. I've talked about interagency collaboration. We do joint trainings to enhance and streamline investigations. We also train together with judicial officers, we train with the investigators, and sometimes partners, UNDP and others also facilitate training for us all. Then I've talked about public sensitization, which we do next. Now, sensitization of agencies focus on investigation and prosecution of electoral offenses, which could include ingredients of the offenses, sample charges. We have also developed quick reference guides to guide prosecutors on what they need to do, what they need to look at to help them review some of those cases. And then the DPP also organizes, as I've said, regional joint trainings with investigative agencies. At the community level, we hold town halls and community engagements, basically on all those things that I've talked about. Next. I think this you may be aware about, making the decision to prosecute. In Kenya, we say that the decision to charge is the prosecutor's determination as to what evidence availed, as to whether evidence availed by an investigator or investigative agent is sufficient to warrant institution of prosecution proceedings against an accused in a court of law, including in electoral offenses. And the decision to charge or not to charge requires an objective and independent analysis of the case. And while the role of the investigator and the prosecutor are complementary, the ultimate decision to charge rests with the prosecutor. And for the young prosecutors, do not take directions from investigators. They'll try and intimidate you, telling you they are knowledgeable, they have seen a lot. It is you who is exercising the delegated powers of the DPP. Guide them, even though they are elder, show them respect, but be firm when it comes to making the decision to charge. You must assess whether it is appropriate and what charges to prefer, including if you decide that you are going to apply an alternative to prosecution, it is you who makes that decision. That is the law, that is the tradition. So they should not intimidate you. There are certain offenses which may require prior, I don't know whether that is the practice here, which may require prior authorization of the DPP. But in this context, if you are having a case against a very influential person, please, I plead with you, inform the DPP so that we avoid scenarios in which we can embarrass the office. Next. Now, once an investigation file is compiled in Kenya, it is normally forwarded to us. We have the central case intake, a central place where all files are received, and there are prosecutors who are stationed there dedicated to reviewing all those cases. All decisions made on whether to prosecute or not to prosecute and the reasons for such decisions must be documented in accordance with the guidelines. And they must complete that form and have it filed in the prosecution file. The standard required in making the decision to charge is whether there is a reasonable prospect of conviction. I think this is what the standard is even here in Zambia. You must consider key evidence and certain minimum requirements in the file which would apply depending on which test. And here we talk about the two-stage test or the threshold test. Next. These are the minimum requirements in a file that is normally forwarded to us before you exercise the two-stage test. We normally want to see the initial report. Very important, just to understand if a report was made, who really made it. Because I've seen so many things in my life as a prosecutor. You want to see the investigation diary. It is telling sometimes. Where applicable, you want to see the correspondences. Then you want to see a brief summary of the facts of the case. Again, I've seen where the brief summary completely differs with what is in the file. You want to see key witness statements, including the complainants, addressing the necessary elements of the offense, the identification of the suspects, or their arrest. The statement of all investigation officers assigned to the case. And I encourage in cases that I handle that more than one investigator records a statement because officers are transferred from time to time. When an officer is transferred, or God forbid, if one dies, there should be someone who should be able to testify. Then any documentary or relevant exhibits, including photographs, financial statements, or any exhibits that you may contemplate when considering electoral offenses. And what are the tests? Of course, the two-stage test, I'm sure you are aware of it. The evidential test, followed by the public interest test. And the evidential test just requires that you consider the sufficiency of evidence. Public interest test in Kenya, we have come to understand public interest to mean all those factors that are in the wider interest of the administration of justice. And most important is that you must be satisfied that there is sufficient evidence. And as a technical person in the law, you are the best person to determine. And if you have done your prosecution-guided investigations well, you will understand whether the evidence is sufficient to prove all the elements of a particular offense. Next. I think that is what I have said on the sufficiency of evidence to provide a realistic prospect of conviction. And what is a realistic prospect of conviction? It means an objective, where an objective, impartial, and reasonable court hearing a case, properly directing and acting in accordance with the law, is more likely than not to convict the accused. A very objective test. You are looking at your court and you are asking yourself, in this case, if I present this evidence and the magistrate acts in accordance with the law, including considering all decisions that have been made on that subject, is more likely than not to convict. If you satisfy that very simple test, then you know that is a case that deserves to go to court. And when deciding whether there's sufficient evidence to prosecute, you should first identify all the elements for each offense, relying on the relevant substantive law and procedural law, including legal precedents. Next, please. Now, once you are clear about the elements, you should address the following factors. we are just reminding ourselves. After all, when you go to church on Sunday or on Saturday, you will be reminded, isn't it? You already know, but I want to remind you. You are going to look at the admissibility of the evidence you are contemplating. How reliable is that evidence? Yeah? How credible? Is it evidence that can be believed? Again, I have seen evidence sometimes presented to me that leaves me wondering, could this really have happened? Is this really reasonable? Relevance. What is the connection between the evidence that you are being given with the offense that is being inquired into? It is you who is going to determine. And if you are not satisfied, ask the necessary difficult questions, and you must be satisfied. Is that evidence available? Yeah? Again, relative to the digital evidence that we were talking about yesterday, they tell us that how you store that evidence also matters. If it is stored next to a magnetic field, sometimes it interferes with the device in which that evidence is stored. So is that evidence available? I was working in the coastal region that receives a lot of tourists sometimes. And you could proffer a charge where maybe a tourist was your witness. At the time when this case is coming for hearing, this person could have traveled. So you need to consider whether the evidence is still available. Sometimes I've seen cases where, like particularly in corruption cases, and even in these election matters, the warehouse where the evidence could be stored could have been burnt. So you need to determine whether that evidence is still available. How sufficient the evidence is up to you. You don't need a lorry load of evidence to prove a particular offense. The sufficiency is left to you to determine. And then, most importantly, I always want to look at what the accused is saying. What is the strength of the rebuttal evidence of the accused person? And we tell our prosecutors that a case that does not pass the evidential test should not proceed, no matter how serious and sensitive the case may be. Yeah? This is how, as a prosecutor handling electoral matters, you will ensure a fair, impartial, and free elections by ensuring that only cases that merit progress to the trial stage. Next. Next. Public interest, as I've said, is what is in the wider interest of the administration of justice. This is the test that we apply after considering the evidential test. And here, the prosecutor exercises discretion. And there are several factors that a prosecutor may want to examine. They are not exhaustive, but they may be relevant. And public interest factors could be, you are looking at the age of an accused person. Yes, you are satisfied, sufficient evidence. But you look at the age of the accused, a 90-year-old man, and you are wondering what you are going to achieve by prosecuting a 90-year-old man who cannot even walk to court. Yeah? So you have to consider whether it is in the public interest or a very strong and influential community leader. Could you find an alternative, just like in the example that I gave you? And this is where a prosecutor is called. Yes, there is sufficient evidence, but is there a better way of dealing with this case, including alternatives to prosecution? Can you consider diversion, for example? Can you consider reconciliation? Other measures that you could take. And then the weight to be attached to each of the factors will also vary according to the facts and the merits of each case. So you are looking really at the circumstances of each case. How serious is this offense? What impact does it have to the society or the victims? These are all matters that, call for you to exercise your discretion on whether you are going to charge or not. But this is very controversial. You need to consult with your superiors. You need to consult sometimes with the DPP so that, because what you are considering may not meet what the DPP thinks is in the public interest. It's very, very subjective. Next. Yeah, those are the factors now you want to consider when you want to exercise public interest. Culpability of the suspect, impact or harm, status of the victim, whether that prosecution would be proportionate to the response. What are the sources of the information, and do they require to be protected? Sometimes when you bring out an issue, I have seen, particularly in serious cases, a whistleblower is taken out. You will not have. So consider whether you need to protect that witness. Next. Next. And then this is the most controversial, but it is the most relevant during this election time, because we are saying that in very rare and unique circumstances, the prosecutor can apply the threshold test to charge a suspect based on prima facie evidence and a reasonable prospect of additional evidence being given. In other words, a file is presented to you. Yes, you are seeing the connection. There's some evidence, albeit not sufficient evidence. And the police are telling you, or the investigator is telling you, give me more time. I'm pursuing these lines of investigation. Within 2 weeks or within 10 days, I'll be able to give you the evidence. It can only be used in early stages of serious cases such as SGBV, violence, murder, electoral violence, corruption cases, terrorism, but only after consultation with your supervisor. So here, we are invoking the threshold test in very serious cases. You want to arrest a certain situation. Something serious is happening. There's a lot of violence escalating outside there. And an influential person who has mass following perhaps has been arrested, but investigations have not been concluded. You are saying, I'm going to put you in, I'm going to charge you, but under Kenyan provisions, a prosecutor must review this case within 2 weeks, just to ensure that the investigators have done their part and that all the cases, all the lines that were outstanding have been covered. If the evidence anticipated is still not available within 14 days, the case should be escalated to the supervisor for direction on the next steps. Mostly, depending on how serious it is, you may extend that period, but you must go to court to seek an extension, because that is now supervised. Somebody in custody without having been charged. And then, in most cases, sometimes we say, release that person, conclude your investigations, and bring the file for us to make the decision. Next, please. Next. That is what you require before you apply the threshold test. Reasonable grounds to believe that the suspect committed the offense. You must believe that there is further evidence that can be obtained. There is a serious case that is making you make that decision to charge immediately. And again, that it is in the public interest, is in the wider public interest to charge that suspect. Maybe he's a person who is very toxic, harmful from their utterances, very violent, has a large following, and something needs to be done to him. Now, where any of those 4 conditions is not met, we normally direct that you can't invoke the test. If there is no reasonable grounds to believe the suspect committed it, if you are not seeing that link, don't charge. If there is no further evidence that is forthcoming, don't charge. In other words, we are saying we are not just going to take someone and put them in on the basis of what the investigator is telling us. They must present some prima facie evidence that this person was involved. Next, please. I think I've already alluded to these minimum requirements which must be met for the threshold test. Next. Now, best practice in other agencies or other jurisdiction, it's all about the National Security Council, I don't know what it is in your country, but the top security council, which brings all the security agencies to collaborate and supervise those security agencies during election period. Because I've talked about the whole of government approach. So in our country, it is called the National Security Advisory Council. It comes together and helps facilitate all the agencies so that they monitor and ensure security during elections. With the judiciary, the Gazette magistrates, they have also their electoral team that is put in place and issues guidelines on how these matters are going to be handled, particularly because we have a time limit within which to conclude those cases. Then the Communications Authority of Kenya becomes very, very important because of the expertise that they have in investigations, particularly relating to digital and electronic evidence. Others are these theological groups. In Kenya, the Conference of Catholic Bishops conduct civic education campaigns on democracy, the rule of law and good leadership, and societal issues affected by governance. And I worship in the Catholic Church, and in the last few weeks, they are taking us through directions or guidelines that have been issued by the bishop on matters related to the election. So that kind of sensitization happens, and it gets people to know how to interact or what to do during the elections. And we work together with all these organizations on these matters. Next. So, for you, as our brothers, and I think in Africa, the people I consider closely related to Kenyans are you, in terms of even the food, how you speak, how you look just like Kenyans. And this is from me to you, my brothers and sisters. Create a rapid reference guide on election and hate speech offenses. This will be very helpful. Particularly, prosecutors can sometimes be very busy and you need to make quick decisions. So a quick reference guide will really help you. It will have the details on the legislation, the section of the offense, the ingredients of the offense, and this will form a checklist when making the decision to charge. And you must note that all offenses, when committed during the elections period, affect the elections process and are deemed to be election offenses. So if there is a murder that has been done in a public rally, we, in our case, regard it as an election offense. It needs to be addressed very fast to prevent any escalation of issues. Have a clear reporting and consulting channels on election matters. You need to have that channel of how to communicate. If it is at a prosecutor at a very low level, something serious has happened, how does he escalate that matter? Who does he need to consult? Who do they report to on that issue? Have that very clear, consulting and reporting channels. Now, embrace meticulous data collection. If you don't have one in the office yet, you can even start by developing simple tools that can help you report on those electoral matters. Because DPP, at where he is, needs to look at the trend nationwide. And this will help him suggest interventions or know what he needs to do, whether it is to sensitize, build a certain capacity in that area to be able to respond to the prevalent crime in that place. Develop an interagency plan of action targeting prevalent offenses per region. This can be done in conjunction with the courts and correctional services. And in this limb, agree with the agencies on matters like bail and bond considerations, the conduct of trial and sentence of prevalent offenses. Because people outside there need to see action. And sometimes the court, fortunately for us, we already have the court users committee through which we can ventilate some of the issues as law enforcement, because it is all futile. You arrest people who are causing chaos outside there, you take them to court, and the court immediately releases them on bail. And immediately they come out, they are received by their supporters. Really, a mockery of the whole thing. Then train prosecutors on trial advocacy in hate speech and electoral justice cases, embrace filing of case submissions, and victim impact statements. In terms of witness protection initiatives, yes, you do not have a legal framework, but nothing prevents you, because this you can start adopting as a strategy for seeing to it that you succeed in prosecuting your cases. I don't think there would be anything wrong if you organized for this witness to be out of reach of people that could influence them. So how you will do it, you innovate around that area. Other initiatives could be social media monitoring, and that needs to start now, because it is now that you can see people building the tempo towards the elections. Then have dedicated prosecutors to do that, and dedicated courts to handle hate speech and electoral justice offenses. Next, I don't know whether there is something else. Next. And that is all I wanted to talk about. I have no conclusion, but I think there is no silver bullet, really. Out of all that I have said, it is you who will determine what is relevant, what you need to do to make sure that you're going to assure the Zambians of a free and fair elections. And I want to wish you all the best, even as you face your elections. Thank you for listening to me.
Thank you so much for that brilliant presentation. We'll have interventions, comments, questions. I see a hand to my left.
Good evening. Thank you so much for the insightful presentation. My question borders on witness protection. So,
Could you kindly introduce yourself?
I'm Annie Mercy. I'm your Kenyan sister from Zambia. Okay. My name is Annie Nkoma, Senior Public Prosecutor from Livingston. My question borders on witness protection. So does it extend to family members of the particular witness? And if it does, to what extent, bearing in mind the large families that we have in our African?
We'll take two more before Mr. Kemo can come through with the response. I saw a hand to my right. Still there? We'll allow the speaker to proceed.
Annie, yes. One of the challenges the Witness Protection Agency experiences is the lack of funds. But yes, it is possible, because a witness who we contemplate protecting could be saying, I'm not leaving my family behind. And so, depending on the gravity, and the weight of the evidence they carry, we could consider taking in the family. This, however, is totally at the discretion of the Witness Protection Agency. Even as an individual, they do not give me information where they keep our witnesses. All I need is to inform them that the case is coming up for hearing on a certain date, and they will arrange for that witness to be produced. How they keep that witness, the level of the protection they are going to give to that witness. Sometimes witnesses are even escorted with armed protection. So it is totally at their discretion, but what I know is that they leave nothing to chance when it comes to protecting some of witnesses. In a case I was handling, some witnesses were very problematic. Some begin to miss their families, particularly when the case drags on for too long. And some sometimes try to escape from, their protected safe houses. So yes, it may be important that they consider protecting them together with their families. Thank you.
I see a hand to my right, the third row.
My name is Michael Nunwe, Senior Public Prosecutor Lusaka. My question relates to, I could hear the presenter that you have prosecutors during election time for purposes of to attend to those matters. I didn't hear you say about the judiciary arrangement, whether you have subordinate court magistrates to be on standby, or you have ordinary magistrates to be receiving those matters. Also, whether during weekends they can still perform such judicial activities. Thank you.
Michael, yesterday I think I alluded to it, and even today, the judiciary have a team that, I just forget the name, but they have a team that they form that is specifically dedicated to handling electoral issues. Now, the law requires that at least 6 months before the elections, the Chief Justice should appoint special magistrates to handle election-related matters. All these offenses that we were looking at are tried in the lower courts at the magistracy level. So you'll find that he has gazetted magistrates to handle those matters. On our side, yes, we have a team, and we work very closely, even with the judiciary team. I have attended several forums where I have had to sensitize judicial officers on electoral offenses, on subjects related to elections, and also met with the leadership of the judiciary to strategize on how we are going to handle some of these things, particularly issues of joint training and how to deploy other strategies to be able to tackle this question of elections. And yes, as you approach the elections, like when we establish the 24-hour call center, we work throughout, including over the weekends. So that is very important. And then in Kenya, it is around the weekends when a lot of campaign is happening. Like right now, even yesterday, I was watching the news back home, and it was crazy. Yeah. If those of you who are following our politics, we had a deputy president who was impeached, and he has beef with the current holder of the presidency. And yesterday it was very bad and happening particularly on national TV. It is crazy. So yes, some of these things are escalated on weekends when the MPs retreat back to their homes and are mobilizing their bases. So that is the time you really need to watch what is happening so that nothing really escapes your attention. So yes, somehow our antenna are up throughout, even on weekends. Thank you.
There was another hand on my left, in the third row.
Thank you for that wonderful presentation. My name is Taonga Nikochiwa, Public Prosecutor, Lusaka.
Kindly speak up. Kindly speak up.
So I was saying thank you for that wonderful presentation. My name is Taonga Nikochiwa, Public Prosecutor from Lusaka. So I noted the emphasis on the relationship between prosecution and investigators. That being said, are there any statutory mandates to the same relationship? And if yes, how have they been implemented into practice? Thank you.
The Office of the Director of Public Prosecutions in Kenya is established pursuant to Article 157 of the Constitution. It spells out our mandate. I was already in the office of the DPP in 2010 when this constitution was promulgated. And one of the first issues we had was, yes, the constitution was broadly spelling out our mandate, but how are we going to operationalize the office? You may want to know that prior to the 2010 constitution, we were a department within the office of the Attorney General. So one of the first things we did was to propose legislation, and we came up with the ODPP Act. And under the ODPP Act, it recognizes prosecution-guided investigations as a best practice. And it says that prosecutors are encouraged to work closely with the investigators, not to direct investigations, because that is the mandate of the investigator, but to guide the investigators. How that works, again, we have spelled it out in the decision to charge guidelines, and we just give soft techniques on how to go about it. And this sometimes is born from what I have seen, how our prosecutors, particularly the young prosecutors, relate with investigators. Even throwing my eyes around this hall, I can see that most of the prosecutors here are very young. Those in my country we call the Gen Z. And the Gen Zs, I have them even in my house. I know how they think. They can be very impatient. But we are Africans. I tell my colleague prosecutors we are Africans, and there's a way we Africans do our things. And I have no reason to believe that that is not the way it happens in Zambia, because I've said we are closely related. We respect our elders. And so when an investigator who is older than you comes to you, first of all, treat them as an elder. Give them their due respect, because that is how they will in turn respect you. But I've seen some prosecutors mistreat them. How many times do you want to tell me that this thing does not have evidence? To the extent that even a file is thrown at it doesn't need to go to that level. You need to know how to build trust between yourselves. When you want to say no, be firm and say no. When they have done something good, compliment them. If they are calling you on your phone, please return those calls. if you're not able to return it. Because sometimes I know you are in court, you're not able to respond to your calls. So return. Those are some things that, you know, the very soft skills you could deploy to be able to build trust between you and the investigators. Then be an honest advisor. Because when people know that you give honest advice, you are doing what you are doing in the best interest of justice, they begin to respect you. And once you create those boundaries, you'll have a very professional relationship and you'll be able to enjoy your work. And anytime you give a decision, it will be followed. You'll not have a scenario where every decision you make, or sometimes, as I've seen, certain investigators fear going to particular prosecutors because of the anxiety that it develops in them if that prosecutor is the one that is on duty and is the one that they have to see. So yes, we have legislation that provides for it, and we have started developing traditions or a way in which we can relate with the investigators. Thank you.
Thank you so much. Mr. Kemo is still available for further interaction. Your presentation, Mr. Kemo, poses a very important question to the prosecutors. What is your contribution towards the development of your country? For me, I think that is food for thought, and we thank you so much for your presentation. A round of applause for him, please. We'll go straight into our next presentation, entitled The State of Human Rights During the Election Period. We'll invite our able speaker, Dr. Pamela Towela Sambo, who is the chairperson of the Human Rights Commission. We'll invite IT to just give a bow for her.
Good morning to everyone. Let me rest on the protocols that have already been established. Let me just say, distinguished delegates, conference participants, ladies and gentlemen. In line with the presentation I'm making, the state of human rights during the election period. Naturally, from the Human Rights Commission of Zambia, which is the national human rights institution established under Article 230 of the Constitution of Zambia. The Commission has both legislative and constitutional mandate for the promotion and protection of human rights throughout the country. I'll just make a point to some of the responsibilities, powers, and functions of the Commission, which are drawn from the Human Rights Commission Act number 4 of 2024, as well as the Access to Information Act number 24 of 2023. In addition, the Commission operates in accordance with the United Nations Paris Principles, which guide national human rights institutions on promoting and protecting human rights and advising governments in a broad range of human rights matters. With this background as a national human rights institution, the Commission promotes and protects human rights in accordance with international human rights standards contained in the various regional, international instruments to which the country is a party. We also rely on what the Bill of Rights provides within the context of the National Commission. The Commission also plays an advisory role in ensuring that national laws, policies, and administrative practices are consistent with the country's international human rights obligations.